Hi, this is Dan Chambers, the founder of Chambers Law Firm. This is the second part of a series that I'm doing on a new law called SB-1437. And if you watched the first part, you heard me say that this is going to radically change certain aspects of murder in California, how murder can be charged, and what prosecutors can do in terms of their theories of murder. In the first part, I talked about what's called first-degree felony murder. In this particular part, I'm going to talk about some other types of murder theories that prosecutors use currently that will no longer be available to them under SB 1437. And if you or a loved one happens to have been convicted of murder under one of these theories, you may be eligible to petition the court to resentence you on a different type of theory. Let me give you an example, because this is a very complex area of law, and I think examples probably illustrate the point the best. One type of murder that will no longer be available under the new law is what is called second-degree felony murder. As if first degree wasn't confusing enough, there is a doctrine in California called second-degree felony murder. And let me give you an example of that. Let's say that you are in a schoolyard with your friend, and the two of you pick a fight with two other people in the schoolyard, a fist fight, and there's an assault basically going on among the four of you. All of a sudden, the person that you're with, your friend, pulls out a pocket knife or some sort of weapon that you didn't know that person had and stabs one of the other two. That person then ends up dying. He doesn't even have to have a weapon. Let's say that your friend then takes that person, puts him down on the ground, and pounds their head on a curb, knowing that that's probably going to kill them. In that situation, under current law, you could be convicted of second-degree felony murder. What that means is it's a felony, an assault, and it has a death involved in it, and you're going to be responsible for that. Now, the difference between that and first-degree felony murder is that first-degree felony murder is only available for the most serious crimes: robberies, burglaries, rapes, kidnappings. In my scenario, in the schoolyard, it's a simple assault, but you could find yourself on the wrong end of a second-degree felony murder because that conduct is, quote, inherently dangerous to human life. Now you can see that could cover a wide variety of different fact patterns. Now, as of January 1, that theory is no longer going to be available under California law. In fact, the law is now going to be that the malice needed for murder can no longer be what they call imputed or put on you just because of the actions of a different person. Let me give you another example of what will no longer potentially be available. And follow me here, because it's a little bit different than the liquor store robbery example I gave in the other part. This time, the facts are the same. Two guys go in, there's a clerk, and there's a getaway driver. Only this time, the clerk pulls out his or her own gun from behind the counter and shoots one of the two people that went in the store. In other words, one of the criminals, one of the guys trying to do the robbery, ends up dead on the floor. His buddy with the gun runs out, gets in the car, and says, "Oh my gosh, you know, my homie just got shot." That's what's called a provocative act murder theory. And under current law, that getaway driver still can be convicted of murder and sentenced to 25 to life under this provocative act murder theory. It's unclear at this point, but my reading of the new law says that is no longer going to be available either under SB 1437. So under that fact pattern, that getaway driver still should be able to petition for resentencing under this new law, because provocative act murder basically put that malice on him and said, hey, you were in for the robbery, you're in for everything. So I think that that theory called provocative act might also go out the window as well. We'll see what the courts have to say about that. Now, there's some other types of murder theories that are going to be changed by SB 1437, but it would take a much longer video. So what I recommend that you do is, if you or your loved one who is currently incarcerated on a murder case, serving a life sentence, if you believe that person might be eligible, please call our office today. We've read through the statute, we're ready to go with petitions for other clients, and more importantly, we're up to date on all of the current case law in the area of felony murder to help you determine whether or not that person's going to qualify. I encourage you to call us with any questions you have. We always provide a free consultation, and we'll be happy to talk to you. Thank you very much for watching.